Welcome back again to the Schiller and Hamilton Podcast. I'm here yet again with David Bartholomew,
Hey,
an attorney with our office. He's stationed out of the Beaufort office, but he handles a lot of family law and criminal law for our firm. And today I think we're going to be talking about just a very simple overview of the divorce process. Is that right, David?
Yep.
Cool. So let's just kind of go through the anatomy, or a very brief overview of the divorce process, okay? We're not going to get into really, the whole what to do if you want to leave your spouse. That's a whole thing we could get into, but let's just kind of start about the actual legal process. So first thing would be the filing of a summons and complaint, correct?
Correct.
Okay. Now, what most people probably know is that there are grounds of divorce, but kind of go through what's the grounds of divorce, or what are people pleading? What are you going to be complaining of when you're filing for a divorce?
Okay. So most people that call us, they call wanting a divorce based on 1 year of continuous separation.
Okay. Or no-fault divorce.
Yeah, no-fault divorce.
Okay.
1 year separate and apart.
Okay.
However, we do get some calls for adultery, desertion, physical cruelty, and habitual drunkenness.
Okay.
We don't really get that many calls for desertion, but we do get some calls from time to time for physical cruelty, habitual drunkenness, usually in play with that as well. But I think as far as a fault ground, adultery is probably the number one that we get phone calls for.
Yeah. And I think desertion is just kind of a dead grounds now. I think it's been overtaken by the 1 year no fault.
Yeah.
Because if I remember correctly from law school, that's literally the last time I think I talked about it. With law school was the fact that it is, or maybe the bar prep, but I think you have to be deserted for more than a year anyway. So, okay. So in order to, am I right to say that, it's been a while since I've done family court. Am I right to say that you have to have those grounds established in order to file for them, correct?
Correct.
Okay. So how does someone go about filing for 1 year's continuous separation without having been already separated for a year?
Well, basically, you file a summons and complaint, but you're asking the court to establish the guidelines or the ground rules for the next year.
Okay.
And a lot of that's done at the temporary hearing.
Okay.
So when you file the summons and complaint, you can make the request for the temporary hearing.
Okay.
At that temporary hearing, it's usually scheduled within 4 weeks of making the request.
Okay.
Once you get in there, that's where you're establishing, like I said, the ground rules. You're really looking at if there's kids involved, you're establishing temporary custody along with a visitation schedule. Mm-hmm. If there's spousal support required, there's a temporary order on that as well. And once again, it is temporary. All right, but it is important. I'm talking with you in the past. It's important to make sure that's where a lot of things play out is at the temporary hearing.
Yeah, I do know that because like I said, I did this for several years before shifting gears a little bit. But it is temporary. It is generally what they call non-prejudicial, meaning that the judge or the court could completely do a 180, and anything that they've ordered temporarily could be switched at trial or later on. And generally that order is going to last up to a year, correct?
Correct.
Okay. And then also I think people probably would understand that it's also going to allow someone to have temporary possession of the property.
Right.
Who's going to get the car, who's going to get the house, who's going to pay for the car, who's going to pay for the house. But, I think like you said, in my opinion anyway, and I'm sure you're seeing this as well, it is about 90% of the battle. Establishing a status quo is so critical. And I think that, when you're going through that temporary hearing, setting the tone for how you're going to live the next year or so, or, 9 months, 10 months, however long it's going to be from your separation, is going to basically establish a new normal that you're going to now have to go up or down from at an eventual trial or mediation or whatever. So let me just go back real quick. So the temporary hearing, like you said, is one of the first things that happens. Now, that hearing is held at court, correct? Now, kind of explain the process. I mean, is it like a trial, or is it kind of like a little bit different?
It's more of a bench trial.
Okay.
You have the judge sitting up there, and essentially the parties are in there with the attorneys if they are represented, and you're going through and establishing the facts of the case.
Okay. Yeah. Now, there's no testimony?
No, it's all done via affidavit.
Okay.
That's where you really get that's where you get all the information in. You support it. You're limited to the amount of information you can get. I believe it's 10 pages that you can turn in as the amount of affidavits that you're limited to with the temporary.
Okay, yeah. And so, just so someone who's going through the process may understand, like they may give their testimony in written form.
Right. Yeah. Correct.
But they're not going to get on a stand.
Right.
They're not going to be cross-examined by another attorney, and they're not going to have, there's not usually too much mudslinging other than maybe what's written down. Okay. So at that temporary hearing, I'm assuming also the next kind of phase of that. Now, everybody knows what they're doing for the next period, but you still have to figure out what the final resolution is going to be. So in that period of time, I'm sure there's going to be discovery. Just like any kind of civil case, we're going to have a fact-finding mission, basically, for both sides. So kind of go through, well, what are some things that you're looking for, or what are some things going to be traded back and forth, and how you go about getting those things?
Well, some of the most important information is going to be the financial information, because at the end of the day, that is the biggest point of contention for a lot of these divorces is the finances. So you're going to be looking for stock statements, bank accounts, bank account information, and any debts. So not only is it what they have in the bank, but also what's owed.
Yeah.
Because that has to be divided up too.
Yeah. And then, I mean, people's retirement comes into
Oh,
this,
yeah.
right?
Oh, yeah, absolutely,
I mean,
yeah.
property they owned. I mean, I know that it can be a very simple process, and it can sometimes be a very difficult process depending on, what people own, if they're hiding things, businesses involved, things like that. Now, in some cases, you also are going to have like written interrogatory questions, and I'm not sure if people understand what that is, but it's written discovery questions that have to be answered under oath. Okay, just for a definition. So there's some other things that you're also going to be seeking information to prove your grounds of divorce, I would assume, right?
Yeah, if you're filing under default grounds, yeah, absolutely. Especially for adultery, you may be requesting text messages or phone records, anything that can go to establish and prove the grounds for adultery, or for instance, physical cruelty, police reports.
Yeah.
Yeah, that's a big one right there. You're going to be going, was there any hospital records? Were there any sheriff departments or anything involved, police departments involved? So you're going to be trying to seek that information out.
To try to prove those
Right.
grounds, exactly, because they do have to be proved by clear and convincing evidence. So, okay. So that's kind of that first process. Now, you've gone through the filing of a summons and complaint. You've had your temporary hearing. You're living your life in this new normal. You've exchanged information. Now, is the next step trial, or what's the next step after that?
Well, the next step is to try to negotiate.
Okay.
You're going to try to negotiate a complete separation of property and settlement agreement.
Okay.
So you're trying to reach an agreement that's satisfactory to both parties, but mainly to your client.
Yeah,
So,
of course.
Obviously.
We're obviously going to be, advocating for our client, but yeah.
But it is a court of equity.
Okay.
So you do want to try to make it a fair agreement so that the judge will sign off on it. And they're going to analyze the financial information that you provide through a financial declaration to the court. But yeah, so in that next phase, though, you're going to try to get an agreement in place. Oftentimes, you'll send a proposal over. It gets negotiated. Certain things get taken out. Obviously, so it's a give and take aspect of it, but you're trying to work it out.
Yeah.
One of the biggest things, though, if there's kids involved, is trying to get a fair custody agreement put in place.
Yeah. This is all too often, something that's a sticking point during a divorce and settlement, unfortunately, is that the children are kind of pulled in between two parents. But now, if you can't work it out just between the attorneys or between the parties, South Carolina is a mandatory mediation state, correct?
Absolutely.
Okay, so kind of explain what that means. Briefly explain what mediation is. Somebody may be listening that has never been to mediation, and then about the whole mandatory part.
So it is mandatory. I believe it's 3-hour minimum that you're required to go. And what you do is you hire a third-party mediator.
Okay.
These people are licensed to be mediators in the state. You hire them. They're not cheap, all right? But you hire them, and they're good at what they do. They can bring new ideas to the table that maybe the attorneys hadn't thought about. They're able to push certain issues. Maybe even your own client doesn't want to do something. They're able to kind of get the ball rolling. They can be very helpful in getting things settled. But regardless, you don't have to agree to anything, though, at the mediation.
Of course.
But you do have to do it.
Yeah. And the whole reason for the mandatory, and I actually was practicing before it was mandatory statewide, and, it was kind of in tester areas and everything, but it really has cut down significantly on the amount of trials that happen in family court. I mean, trials now are extremely rare. Contested hearings are not, but actual trials are kind of rare. And that mandatory piece really does, resolve probably, I don't know the statistics, I would imagine 95% of cases probably, get resolved by mediation, if not before. Now, let's say you go to mediation and you resolve the case. We're going to fork now two different ways. Let's say you go to mediation or you have a separation agreement that is negotiated between the parties. That now, I'm assuming, or I do know, but it has to be approved by a court, right?
Correct.
So, what are the court looking at, when they're approving that?
Well, you make the request for the final hearing.
Okay.
And when you go, you present that agreement, and they go through, and they want to make sure that each party entered into it voluntarily,
Okay.
that they've had a chance to familiarize themselves with the financial statements of each party, that they weren't coerced, that they weren't drunk, that they weren't high.
Yeah.
They want to make sure that they were of sound mind when they entered into this agreement and that there aren't any issues, because the court doesn't want to approve an agreement that the parties don't agree to.
Exactly. And like you said, I mean, there is some coercion. There is duress. And we're not talking about the stress of going through a divorce. We're talking about, hypothetical gun to your head type thing, of coercion, and duress. And then so once it's approved by a judge, it is then a final order.
Subject to the contempt powers of the court.
Okay. Yeah, and that is pretty critical because, we do get a lot of cases, or we have gotten cases before where you have people breaching the order, and I know that's one thing a judge asks you. Do you know what's in this order? Do you think you can comply with it?
Yep.
And knowing the fact that you could be thrown in jail for up to a year, are you willing to comply with it?
Or what is it? Was it 300 community
300
service hours? Yeah.
Community service, and there's also a fine.
$1,500.
$1,500 fine. Plus attorney's fees if you do get ruled back into court. But we won't get too much into rules right now. But so that's obviously the process if you can settle the case. I mean, I think the easy answer to the next question would be is, if you don't settle, what happens?
You're going to trial.
You're going to go to trial. Now, is that trial basically like what people may see on TV?
Similar. There is testimony in that one. And at that point, you're laying it out there. There's the rules of evidence apply. You're presenting the evidence, any information, cross-examine, everything that you would expect in a trial is there.
Mm-hmm. Minus a jury.
Yeah, well, minus a jury.
Like you did say earlier, I mean, what people may not know, bench trial is just, a trial that is presided over by a judge. Okay. So in family court, it is still just one judge. There's no jury, there's no panel of judges. It's still one judge. But like you said, you have witnesses, you have statements, you have cross-examination of witnesses, you have evidence procedures, everything like that. So, okay. Once everything is done like that, I do kind of want to just kind of go back real quick. I think we kind of glossed over it. Now, if someone has not been separated for a year and they've gotten to that final stage, whether by agreement or by trial, does that resolve the issues of their marriage?
Now, you're talking about if they filed under a no-fault basis. Mm-hmm. Yeah, so if they filed under a no-fault basis and they've been able to reach an agreement, correct? Mm-hmm. They still have to wait however many more months it is until they reach that year mark before they can go in front of a judge to get a final decree for divorce.
But they've resolved all the issues.
Right.
Say, like you said, property, debt, child custody, child visitation, child support, alimony even possibly. That can all be settled, finalized, close the book, but you're just not legally divorced.
Right. You are still technically married.
Until that year.
Yep. So you got to be careful.
Yes.
You are still technically married during that period until there is a final decree for divorce.
And I've had that question. I know when I was practicing family law, and I'm sure you already have too. Yep. But yes, you are still legally married. You're still subject to possible adultery and possibly a future divorce based upon the adultery. So I know that was kind of a brief overview, but, we wanted to just kind of give a very just toe in the water, for you coming on and also just for everyone listening because we're kind of moving into a new practice area here for the podcast. But is there anything you kind of want to just tell me a little bit about yourself and your family law practice? What makes you different in family law practice of other attorneys and things like that? And, if someone needs to call you.
Well, I think one of the big things that sets us apart is, one, we're not charging everybody nickel and diming. We're not nickel and diming people. Mm-hmm. We're trying to maintain open lines of communication. Mm-hmm. We're trying to keep costs down for the client. There obviously is a cost associated with it, but we're not trying to break the bank here to get this done.
Yeah.
So we want to help people. We want to get the job done for them. We want them to be happy about it, but we also don't want them to go broke in the process.
Yeah.
And family court is not a cheap area of the law to practice in or to get involved in.
That's just very true. Unfortunately, and there's no public defenders.
No.
For divorce, there's no right to counsel, really. I mean, there's obviously indigent services and things like that, but just like anything else, you do need counsel. And so, yeah, I do love that when you've come on, you kind of prided yourself to, just like all of our practice areas, and our firm culture as a whole is we are serving people too. And I think, your way of doing that is to, like you said, we're not going to nickel and dime, and I love the fact that you've done that. I remember you telling me that when you first came on that, I think what is it? You waive a certain number of hours of communication type thing?
Yeah. Each month, depending on the needs of the client, we try to get waive certain hours of communication, depending on the complexity of the case. Yeah. But for the most part, it's usually waive an hour or 2 hours of communication. Mm-hmm. But I mean, that at the end of the day, that saves, a few $100s every month.
Oh yeah. That's what people don't understand is, so, billable hours are billed in 6-minute increments. Yeah. So even just checking a voicemail, if you're charging $200 an hour, that's $20.
Right.
Check a voicemail, $20. Answer an email, $20 to $40 maybe even. An hour phone conversation, which I'm sure you have seen, I have had, happens almost weekly, maybe even daily, an hour-long conversation with a family law client that right there, $250 to $350 depending on your hourly fee for a phone call. So I do love that, and I commend you, for stepping right into the firm culture here at Schiller and Hamilton to say, what, we're going to be here, but we also have your back, and we want to make sure that you're going to have what everyone else needs, has the right to have, which is an attorney that is open to you and available. So
well, you need open lines of communication.
Exactly.
You're hiring me to help you.
Yeah. The last thing we want is someone to say, I really need to tell David something, but I don't really want to have to pay him right now for that. So I commend you on that. Again, welcome to the firm again. I know you've been here a while, but, welcome. And I'm glad that you're stepping into this role, and I can wish you the best of luck with family law. Like I said, I have been there, and I'm sure this will be the first of many times that you and I sit down today, or not today, but, in the next few years to talk about family law. So, again, welcome, and thanks, everyone, for listening. I know this was a brief one, but I really appreciate everyone listening and watching the Schiller and Hamilton podcast. If you need any issue or have any questions about a family law matter, please give our guy David a call. He'll be glad to talk to you, and hopefully we can help you out. Thanks.
Thanks.